Hi, this is Josh Blackman. Welcome to the Harlan Institute Virtual Supreme Court competition. This is the round of 4 second match. We have 2 teams today. Representing the petitioners, we have Aria Hawk and Nidhi Nair from Lake Oswego High School in Oregon. And from the Baldwin School in Pennsylvania, of Emmy Maida and Lighthouse Wu for the respondents. And I'm joined by 3 distinguished judges, Tommy Berry, Jacob Hubert, and Corbin Barthel, who will be presiding today. Chief Justice Berry, take it away.
We'll hear argument next this afternoon in Moody versus NetChoice. Petitioner?
Your Honor, and may it please the court. My name is Aria Hoke, and along with my co-counsel Nidhi Nair, we represent the petitioners Ashley Moody and the state of Florida in today's case. This court should find that the provisions of Florida's SB 7072 should be upheld, with our 4 main reasons being that the covered platforms are common carriers, social media companies lack editorial judgment, the Florida law includes narrowly tailored hosting requirements, and also contains disclosure provisions, which will enhance user speech. This bill does not violate the First Amendment protections guaranteed to the social media companies.
Firstly, the covered social media platforms are common carriers. Black's Law Dictionary defines common carriers as companies that offer services to the public over wires or satellite systems, which social media companies fall under because they are major conduits of information within today's digital society.
State ex rel. Webster v. Nebraska Telephone Co. established that although a telephone company imposed reasonable rules and regulations upon their customers, they were still obligated to fulfill the common carrier obligation of being indiscriminate in their dealings.
The 11th Circuit's decision held that the covered platforms are not common carriers because they make individualized content and viewpoint-based decisions about which content to disseminate, which was therefore considered protected speech and triggered First Amendment scrutiny. While the court based their ruling off of Turner Broadcasting v. FCC, we firmly disagree with their interpretation of the case. In reality, the 11th Circuit ruling asserts that the must-carry rules are content neutral, and thus are not subject to strict scrutiny, and that the challenge regulations do not justify application of First Amendment scrutiny.
It is also important to consider that while SB 7072 requires platforms to host speech they normally wouldn't, the legislation doesn't entirely eliminate all censorship and regulation of content like obscenity, for example. The social media companies must apply whatever censorship, deplatforming, and shadow banning standards they adopt in a consistent manner among their users, which demonstrates how the law is narrowly tailored to enhance user speech and content rather than portray a certain message on behalf of the platforms.
Secondly, social media companies lack editorial.
Let me just interrupt. For some reason, when Nidhi's speaking, it's loud and clear. When Ari's speaking, the audio drops. I have no idea why. You hearing the same thing?
Yeah.
I apologize for that, Your Honor. I can try and move closer to where Nidhi is in relation to the speaker. Does this help?
Good now.
Yeah. Okay. Yeah. Okay. I'm going to resume the clock. I'm sorry. I really didn't interrupt you, but I had trouble hearing it. Okay. I'll resume.
Of course.
Thank you for clarifying.
Sorry about that.
We can continue from where we left off. Secondly, social media companies lack editorial discretion and do not have the same protections as a newspaper. Companies cannot be treated as the publisher or speaker of information that they merely distribute, as stated within Justice Thomas's opinion of Biden v. Knight. Social media companies exist to disseminate and host users' content, not convey their own message.
While NetChoice asserts that they act much like a newspaper editor in curating the speech that they will publish, this reasoning is invalid and should not be upheld in this court. Unlike journalistic enterprises, the covered social media platforms simply host other speech rather than publish their own. They cannot be classified as being allowed under editorial discretion because, unlike newspapers, digital platforms hold themselves out as organizations that focus on distributing the speech of the broader public.
Throughout this case, the respondents referenced Miami Herald Publishing Company v. Tornillo to justify that requiring platforms to host certain content violates the First Amendment. We once again must disagree with their argument. The logic of Tornillo cannot be applied to the covered social media platforms in the NetChoice Trading Association because journalistic enterprises and newspapers have an intertwined relationship between their message and content, which permits editorial discretion. In comparison, social media companies do not have a message, so therefore they cannot be considered a newspaper.
While it may be tempting to assume that social media is the same as a newspaper, the covered platforms lack First Amendment protection and do not have editorial judgment. The marketplace of ideas must be upheld through SB 7072, and we urge this court to find a plainly legitimate sweep of the law's application, to vacate the preliminary injunction, and to remand this case back to the lower courts to dismiss, as there is no valid facial challenge.
We now welcome your questions.
Counsel, Am I understanding you correctly then that all these major platforms need to do is start interspersing more news in their newsfeed, becoming more of a product that mixes both people's views and the news, and they now fall under Tornillo? Is that what you're telling me?
No, Your Honor. Social media companies cannot be compared to newspapers, not only just because their main intention of existing is not to disseminate news. Social media companies, although some of them do portray some information that is user-generated content and some journalistic enterprises, the entire point of having an account on a social media platform is to connect with others and be part of the digital public square. So just because if we require these companies to host certain news content, that does not give them the same protections under Tornillo because they are not editorial enterprises.
Counsel, you lean awfully heavily on the common carrier theory. It opens your brief. It was a big part of this opening argument. It's a complex concept. I mean, and then you're mixing in some stuff about Section 230 in there from Justice Thomas. I'm just not clear what it's doing here. If the platforms aren't expressive, it seems like you have a very strong case, and the First Amendment is not an obstacle to SB 7072. If they are expressive, I don't really see what common carrier theory adds. So why are we leading with that? What is it? What weight is it carrying here?
The inclusion of common carrier doctrine upon social media companies rather than defining them as being editorial enterprises that have editorial discretion would allow for our law to go into effect and would not be affecting the free speech rights of newspapers because common carriers still have to be indiscriminate in their dealings. The entire purpose of leading with the common carrier and defining it as such is to avoid any complications as to whether or not our statute violates the First Amendment rights of these social media companies, as they have none because they are common carriers.
Can you tell me, so you're saying that the law is content neutral because all they have to do is apply their own rules, and they have to do that consistently, and that makes your law narrowly tailored. I'm sorry, I don't understand that at all. What does consistency mean? I mean, there's no definition in SB 7072. It looks like you're practically expecting us to create like a common law of consistency under the law case by case. I mean, that sounds like a huge undertaking. It almost makes me wonder if this law has a vagueness problem under the Constitution.
Your Honor, we agree that this law is quite vague. There is a clear lack of definitions, which is why we would support remanding this case back to the lower courts as long as we remove the preliminary injunction that was held in the district court. As Justice Ketanji Brown Jackson said in the oral arguments, there's a lot that we don't know about this case. The bill is very vague, but since the plaintiffs brought forth facial challenges, that means that any application of this law that's constitutional would establish a plainly legitimate sweep. So therefore, if we look to platforms like Uber, Venmo, and Gmail, and Etsy, which could be considered as covered social media platforms under this law's definition, we can see that if they were to apply these standards, disclosure requirements, and the hosting moderation content policies within the law in a consistent manner according to their own policies, that would be constitutional because they're not expressive and they don't create their own speech.
However,
I'm sorry, counsel, what I'm asking though is, how is it not so vague that the platforms don't have fair notice of how to comply with it? It's a very separate problem from whether, the facial as applied challenge. I'm suggesting this law might be void for vagueness.
Your Honor, we contend that this law would not be void for vagueness because the vagueness doctrine is one conjoined hand in hand with the overbreadth doctrine, and those both apply to First Amendment challenges. However, as petitioners, we assert that there is no First Amendment issue at hand here because we are regulating the conduct of these platforms rather than the speech. Additionally, as my co-counsel has stated, if the court were to determine that this law is too vague, we ask and humbly urge that they remand it back to a lower court so that the state legislator can clarify it rather than the Supreme Court.
the governor admitted when he signed this that they were targeting these platforms because they have left-leaning views. Doesn't that make the entire law void for impermissible government bias?
No, Your Honor. Despite what Governor DeSantis or any political motivations may convey about the bill itself, if we look to Crawford v. Marion County, that's an example in which this court still rejected the facial challenges and upheld a law despite its political motivations. So I think we should completely ignore any of the motivations that have been conveyed as in regards to why this law was created in the first place. If we look at the actual implications of the bill, it clearly enhances the marketplace of ideas and protects users' speech, which is really the heart of the bill that we are arguing today. Your Honor, I noticed we're running a bit low on time. Is it okay if we conclude?
Go ahead.
While it may be tempting to,
I believe we already concluded.
oh,
I'm so sorry about that. There was a little bit confusion of what we had stated, but I believe we already concluded. Would you like us to repeat our conclusion?
That's fine. You can wrap it up in your rebuttal.
Okay.
thank you, Your Honor.
Thank you.
Thank you, petitioners. Respondents?
Thank you. All right. May we start whenever?
Yes.
Oh,
Go when
Miss-
ready. Thank you.
thank you so much. Mr. Chief Justice, and may it please the court, the Florida statute facially violates the First Amendment. Florida misunderstands censorship. As Manhattan v. Halleck affirms, the First Amendment is premised on mistrust of government power and should only apply to state action. Under the guise of promoting free speech, Florida violates this principle by regulating speech of private companies and extends state power to a point never accepted by this court. Furthermore, social media companies have protected editorial rights. Just like newspapers in Tornillo and parades in Hurley, they curate content for their users to pursue a message. And this right to exclude protects the free marketplace of ideas. This model is also absolutely essential to their generation of revenue and their expression, and restricting it would impose an undue burden like in Zotterer. Furthermore, our friend's assertion that social media does not practice expressive speech simply blinks reality.
Florida's law fails under strict scrutiny as it discriminates based on content, speaker, and viewpoint. The law sets arbitrary standards that singles out particular websites, and the governmental interest is purely manufactured. Moreover, the law unconstitutionally compels speech in defiance of PG&E, Tornillo, and Zotterer. The disclosure requirement is too burdensome that it will create a chilling effect on the company's free speech rights. Social media platforms are also not common carriers nor public forums and should not be converted into either. Unlike Prunia's shopping mall, social media exercises editorial discretion over their content and fundamentally differentiate themselves from common carriers. If the government has an interest in changing that status, the decision should be left up to Congress to avoid state pandemonium. Today, we ask this court to uphold the 11th Circuit's decision. We welcome any questions now.
Counsel, in your brief, you say that if the government regulates private content, it would threaten the uninhibited marketplace of ideas in which truth will ultimately prevail. I'm not sure I understand. It seems to me that's what the platforms are doing. Aren't the platforms the ones throttling an uninhibited marketplace of ideas with the way that they censor content in a potentially biased manner?
Your Honor, with all due respect, that's simply not true. What we see the social media companies doing is pursuing their message, and that itself is speech. When we look at the bigger picture, we see that the government is censoring the social media company's speech, and what the social media companies are doing to their users is merely editorial discretion and just not censorship by definition.
Counsel, what is that message that the social media platforms are disseminating?
Your Honor, by curating their content using their moderation policy, social media companies are having curated a specific feed for their users that conveys their own message. It's a collection of different content that is geared towards a message they want to pursue.
I'm sorry, what is the message?
Your Honor, the message is, for example, if social media takes down a user, that most likely means that social media does not agree with what the user is promoting.
If social media promotes a certain message by featuring it on a user's feed, it means that they agree with this message, and that's what they are trying to say.
But visitors just visiting the site wouldn't even know that a particular tweet or post had been taken down. How would they get that message of disapproval by not seeing what they don't know was ever submitted?
Your Honor, the not seeing what was submitted is not what we should really be focusing on. For example, in Tornillo, their users, their readers probably didn't know that the Miami Herald denied the governor or the government official's right to be on there. However, the court still decided that that Miami Herald was pursuing an editorial message that had to be protected under the First Amendment.
We believe that it is within social media companies' rights to distance themselves and deplatform or ban whatever message they want off their platform, and they have the freedom to not disclose this information or notice their users, because that's part of their rights, as this court has established in various precedents.
Do you need to send a message to have editorial freedom under the First Amendment?
We believe that sending a message is the result of having editorial discretion. However, it's not a requirement in order to have editorial discretion. In fact, as long as, because companies are private entities that shouldn't be governed by the government, that immediately gives them the right to exclude or the right to curate their content.
Counsel, Rumsfeld is one of the main cases getting thrown around here. The law schools had to host military job recruiters. Why doesn't that get us at least to a hosting right? I feel bound when I read Rumsfeld to at least enable Florida to tell the platforms, well, you have to allow a profile the person can post. Maybe you, the platform, don't have to amplify it. You don't have to put it at the top of the news feed. But why isn't Rumsfeld? Why doesn't that stand at least for a basic? We have to host you.
Thank you, Your Honor. This is a great question because we think the Rumsfeld deal with a different question here at hand. The Solomon Amendment in Rumsfeld does not do any requirements to the law school, they did not impose any kind of speech on those law schools. Instead, they just favors and rewards certain kind of speech from those law schools. So we think it was a completely different case, and it showed the government how they should favor certain kind of speech if they want to.
But didn't the court in Rumsfeld say it was a government conditions case, that they were going to treat it effectively the same as if it was a mandate? I thought the court explicitly said it didn't change the outcome whether they were giving more money for hosting these speakers or whether they had just outright mandated it. Is that your understanding of the case?
Sure, Your Honor, but one of the main differences is that the government in this case had a interest in promoting military recruitment. However, we don't see such an interest happening in Moody v. Net Choice. In fact, this interest is really manufactured, especially seeing that no people have sued the social media companies for abridging their First Amendment rights. And also the fact that our friend's best case.
I'm sorry, you think no one has sued the social media companies asserting their First Amendment rights?
No one has sued and won.
Oh, no one has sued, and because I think it is a different question. If people are upset and they're suing the social media companies, even if their lawsuits don't prevail, Florida, why don't they have a consumer protection rationale right there? Why isn't that the grounding for this law, and why would that be any weaker than the government's interest in Rumsfeld?
Your Honor, because there's a First Amendment interest at hand, and the First Amendment interest we're talking about, it's social media's free speech right. And we think that should prevail unless there's another challenge that being brought forward.
Right. What we're saying is that in order to really consider First Amendment rights that are really so much important to our democracy, we need to think about what's really at stake here. And we realize that this statute would completely abridge the social media companies' rights for no compelling interest.
Did the court apply strict scrutiny or even intermediate scrutiny in Rumsfeld? I thought the court said that there was not, it wasn't even implicated, that the compelled hosting didn't inflict any kind of First Amendment injury.
Your Honor, in fact, we don't think Rumsfeld is an equivalent we should be comparing to, because it concerns a very different scenario. But to answer your question, we believe in NetChoice's case, we should apply strict scrutiny because it concerns their editorial discretion, their free speech rights.
And it's also content-based, yes.
Counsel, your friends on the other side brought up concurrence by Justice Thomas, in which he suggested that there might be Section 230 implications here. I've heard it suggested that what's actually going on here is the platforms have the benefit of Section 230. That's a liability protection from them. And in accepting that protection, they are opening themselves to demands from the government that they be even-handed in how they moderate content. Are you aware of that argument, and do you have thoughts on it?
Sure. Just to confirm, are you referencing Murphy v. Missouri recently? Or...
No, and I don't want to take you too far afield if you're not familiar with it, but your opposing counsel brought it up. So if Section 230, if you think it has no bearing here, you're not familiar with it, I won't press the matter. But if you have thoughts, I would like to hear them.
Certainly, Your Honor. We do have thoughts on Section 230. So the thing about Section 230 is that what Congress is doing is promoting social media companies from using their editorial discretion.
So Section 230, as we read it, gives social media companies liability from the objectionable content, but it also, in the bigger picture, it gives social media platforms a lot of freedom in regulating, and having that freedom is very essential. In fact, we think Section 230 is a beneficial argument, a beneficial source for us, because it gives social media so much freedom in editing their content.
But is there an analogy here with Rumsfeld? I mean, Rumsfeld, you're getting money from the government, so host military job recruiters. Here, you're getting Section 230 protection, so host speakers. Am I making too simplistic an analogy there?
Your Honor, could you elaborate on that question a little bit? I'm not sure we completely understand.
Well, it does seem that in the background here, there's a benefit being conveyed by the government. You're saying it helps you because the government's giving you all this freedom for how you moderate content, but in exchange, you're getting a liability protection. So why shouldn't the government now have more license in telling you how you're going to wield that discretion?
Your Honor, we believe that the Section 230 liability clause and abridging the freedom of editorial right doesn't go hand in hand. We think that it poses two scenarios. On the one hand, social media can stir away from those harmful content. For example, we see in the case of, I believe it was the case concerning hosting terrorist content, but under Section 230, social media are free from liability. I think it was Gonzalez v. Google. On the other hand, social media companies have editorial rights in choosing what to host and what to represent in their message, if that makes sense.
If a social media company could just put up a disclaimer on every single post, we disagree with this, we agree with this, why doesn't that give them all the same expressive rights that they had before?
Your Honor, we believe that social media, like all private entities and speakers, should not have to host a speech they do not agree with. As we mentioned in Hurley, in Tornillo, those are the principles this court has consistently upheld, that if you're a private speaker, you enjoy the full right of not have to align with the message you don't agree with. You can simply take it out or refuse to host it.
Furthermore, we think that would impose an undue burden, because for social media companies to go through every single post and write those disclosure requirements is a huge ask that the government is making and would impose a burden that should be struck down, like in Zotero.
You're already moderating. You're already say that you take down tons of posts. So couldn't you just change the algorithm to instead every post you used to take down, now you put the "we don't like it" disclaimer on it? That seems like it would take no more effort.
Your Honor, that would be a scenario, that would be a method the social media companies can take. However, the government, again, cannot regulate companies to do that, because that would be compelling speech, the government compelling speech from a private speaker, which is unconstitutional in every application.
And
But
when,
you suggested, I think, at the outset of your argument that, well, if they keep something up, it means they agree with it. If they take it down, it means they disagree with it. But absolutely nobody views what goes on social media platforms in this way. Nobody thinks that a Facebook post is something that Facebook would agree with. If they take it down, then that implies that there was some disagreement. But as my colleague mentioned earlier, that you don't even know when they take it down. So like nobody is looking at their feed and thinking that this is a coherent message of this is what Facebook believes, right? And therefore, when you compel posts to go up, you're not compelling speech by Facebook. You're just making them tolerate somebody else's speech, aren't you?
no, respectfully, we think that by what social media is doing is very, very expressive. We see that, for example, the fact that such controversy is arising clearly shows that Florida is expressing a message. Thank you.
Thank you.
You can take a couple more sentences if you want to fully answer that question.
Oh, Your Honor, what my co-counsel is saying that because Florida law is so targeting and it's specifically outlining social media's censor, which the word choice we do not agree with, it exactly points out that social media is using their editorial rights. Thank you.
It's expressive.
Thank you, respondents. Petitioners, rebuttal.
Thank you, Your Honor. Do we have a timer? Oh, perfect. Okay. We would like to address several of the main arguments from the respondents in this case, including severability, plainly legitimate sweep, and the overbreadth doctrine. Regarding Section 230, our friends have made some contradictory arguments regarding its application in this case. They claim that platforms remove content, which therefore constitutes a message on behalf of the company. Yet Section 230 draws a clear distinction between platforms and the content that users generate on these sites. There is no reconciliation of these ideas, and in addition, we would like to emphasize that the precedent of Rumsfeld v. Fair does stand in this case. In the same way that law school students wouldn't know the reason behind the presence or lack thereof of military recruiters on campus, the same can be said for users when they see or don't see certain content in their feeds on these covered platforms. The issue of severability has become particularly relevant when placed in the context of facial and as-applied court preferences. If this court were to categorize either the hosting or disclosure requirements as unconstitutional, we would still urge the court to reject the facial challenge rather than invalidate the statute by simply trimming the potentially problematic provisions. According to Ayotte, the touchstone for severability surrounds legislative intent, and the state would prefer what is left of the statute after being severed rather than no statute at all. Our main legislative concern in filing SB 7072 is the protection and the security of the free dissemination of public speech in the modern telecommunication marketplace. The plaintiffs in this case brought forth a facial challenge, meaning that the burden of proof for the respondents requires demonstrating that there is no plain legitimate sweep of the law's application. They must also abide by the Salerno standard, which requires respondents to show that no
Counsel, why? I don't understand why the Salerno standard's coming in here. This is a speech case. Court recently decided Americans versus Prosperity versus Bonta. There's Stevens versus United States. It even seems you're stating the First Amendment standard, which is substantial number of unconstitutional applications in relation to the law's legitimate sweep. So are you standing by Salerno here? And if so, why?
We do stand by Salerno here because we believe that in order to prove that there is a facial challenge, although the Salerno standard has never been applied to a First Amendment case, again, as we've previously stated, we don't believe that this case concerns or implicates the First Amendment in regards to the social media companies. Instead, that we find that the Salerno case is a perfect application
here, and that the respondents must abide by that standard and must prove that there is absolutely no set of circumstances which show that the law is unconstitutional in its application.
In addition to what my colleague said, if we use Bonta as a precedent to base this decision off of as well, we can see that the court held in Bonta that disclosure requirements must be substantially related to a sufficiently important government interest. And the disclosure requirements within SB 7072 can be held to the same standard because they're pursuing the sufficiently important government interest of protecting the marketplace of ideas and enhancing users' speech in the covered platforms under SB 7072. Oh, I think we froze. Shoot.
We can hear you.
I'm sorry, Your Honor. I think we froze for a second.
Yeah, your screen's frozen, but we can still hear you. Oh. No. You're back.
I'm sorry.
It's last time we had the same exact issue where passing period came and then everyone started moving around and then the Wi-Fi got all crazy and passing period just started. So apologies for that, Your Honor.
Don't worry about it. Get back in when you're ready.
Thank you. As I was trying to say earlier before the Wi-Fi cut out, if we look to the precedent of Bonta, we can see that the court held that disclosure requirements must have a substantial interest and relating to a sufficiently important government interest. So if we apply the same standard to the disclosure requirements within SB 7072, we can see that the government has a sufficiently important interest in enhancing the marketplace of ideas and protecting users' speech on the covered platforms under SB 7072.
Do you see Buckley versus Vallejo as a problem for you there? My understanding of First Amendment law is the government has no business making sure that voices have sort of equal soapboxes like that.
We believe that the government does have an interest. I know that the respondents have said that there is some kind of difference between a private business and the public government in regulating speech or regulating conduct in our case as regarding to SB 7072. However, we find that the implication of private businesses versus public government, that distinction is null here, as our law is regulating conduct, not speech.
All right. Thank you, petitioners. The case is submitted.
Thank you.
All right, very good. Let me come back on camera. That was a very strong round. I really have to remind myself when I do this competition that you are all in high school and that you're not actually lawyers and you've never been to law school and you're citing cases and citing statutes and distinguishing precedents in ways that, I think a lot of law students can't even do. So this competition is always a highlight of my year because it gives me sort of confidence that our Republic is in good hands. If the four of you go on to do law or whatever else you do, will be great. But I think you have very, very promising futures ahead of you. Hope whatever college you go to, you do moot court, you do mock trial, you debate. These are skills that will never leave you, and I hope this will at least have some impact on your ability to perform. I've given you a lot of feedback. I've seen you grow the last actually couple of years because you participated before, and it's really impressive. It's only through practice that you get better at this. It's not something you're born with. Anyone says you're born to be a lawyer. No, that's nonsense. It's simply not true. And the more rounds you do, you go back and you watch the video, like, oh, I should have said this. Oh, why didn't I say that? Or, oh, I missed that point. I could have done this. And then you're going to just beat yourself up, and that's okay. You're allowed to do that. In fact, every lawyer does that when they read the transcripts. Like, oh, I missed that point. So this is all a good learning experience. You've grown, you've thrived, and it just makes me extremely proud of what you've all done. And happy to go to my dear colleagues to me give some more feedback, but really all positives.
Yeah, I echo that entirely. Extremely impressive, blown away by that your high school students. I've seen a lot of law school moot court competitions, and you're absolutely at that level already. So you should be very proud about all the work you all put into this. And these case as well, and many of the precedents, and many many more than a lot of law school mooters would know. All look very professional presentations. In particular, the seamlessness of switching back and forth, I was really impressed with. You clearly sort of knew what each of you were going to focus on, and knew when to pass the baton back and forth, and I thought it was really effective in terms of division of labor in that respect. Just not very many, in criticisms, and they would all basically be nitpicks. I think petitioners, the opening statement, we were told at the Supreme Court it's roughly like 2 minutes. I think it went a little long, like closer to 4. And especially when time is so tight, you want to make sure that this applies to both sides. You want to make sure there's enough time for questions. And so you don't want to get to the point where the judges are sort of wondering, like, should we cut in? How long are you going to go? And that type of thing. So I think it's better, in a real case, the most important thing is dealing with the judge's concerns. So I would prioritize making time for questions rather than the opening statement. There was one point, petitioners, where the main thing that struck out to me was, I think it was going back and forth with Corbin about the vagueness of the law. And I think you conceded that it was vague. And I think, again, this is advanced level strategy, and the focus of this case isn't really the void for vagueness doctrine. And I wouldn't even be sure whether you guys know of that, because I don't think it's really in any of the precedents assigned. But if this were a real case, you definitely wouldn't want to, as government lawyers, never want to concede that a statute is vague, because there is this whole other doctrine that will get you in trouble, that you can get a whole law struck down for that reason. So I wouldn't concede. Yeah, the strategy was correct. You wanted to say basically there are uncertainties here, and so a facial challenge shouldn't work. You just don't want to adopt that language of conceding that it's vague. You wanted to try to find like a different word for it, like there are still uncertainties or something like that. Respondents, again, I think, very polished, very smooth, just very few nitpicks. I think there were a couple times, I think it was respondents, hopefully, that where you said, like, with all due respect or with respect. Most judges will say, like, there's no need to, if anything, it sounds passive aggressive or reverse.
Yeah.
I remember, who was it? Judge Easterbrook once, like, snapped at he's a judge on the Seventh Circuit, and he said, when a lawyer says that, I think that they want to say, you dummy, here's why you're full of it.
I promise that was not the intention, but thank you for letting.
No. They wouldn't be. I mean, obviously lawyers say it all the time, but you don't have to worry about pushing back. You can just jump right into it. And in my general advice is, any sort of throat clearing with respect, we think you can just skip all that and just jump straight into the answer. And I think that, there were a couple times, I think, respondents where you kind of asked for clarification of the questions, and that can cut both ways. You don't often see, I think, professional lawyers, high-level advocates generally don't do that. They kind of dive in, and if the judge wants to correct them or redirect, they'll let them, because it can kind of make it a little bit awkward or slow things down if you just sort of say you're not sure. But at the same time, it's not the worst thing in the world, and it's especially if you have a good answer after the clarification. So I'll stop there.
Thank you.
As I said in the other one I did, I feel sheepish giving any kind of feedback to people who did much better than I would have done in a high school moot court. I thought it was fantastic. I thought both sides were very solid. Petitioner in particular, I thought it was a solid opening, and I commend you guys for overcoming multiple technical issues. I know that can be harrowing, and you did very well in dealing with that with aplomb. Yeah, Tommy was talking about asking questions. I was very tolerant of that because we had some weird things in this oral argument where we dipped into stuff that occurred in the oral argument at the Supreme Court, including things that weren't necessarily in your cases or whatever in the prep materials. And you have to be careful about that. Something comes up in oral argument and it might sound promising, but it's not. You're not getting a full treatment of the issue in the oral arguments. You have to be a little bit careful when you start raising issues that maybe haven't been fully ventilated simply because they came up with oral argument. I would just advise be careful with stuff that happens there, because you start bringing up these standards and you open the door to maybe complicated issues that are going pretty far afield. And hence, I would normally say it's a bad idea to ask questions of the judge. The judges are not the ones sort of on the spot, but I was much more tolerant of that here because it was a little unclear at points how far outside of your brief and all that we were going. On the rebuttal, you need to be careful with having pre-prepared rebuttals. If you have some issue that you raise or want to raise and it doesn't come up in your opposing counsel's argument, and then you raise it in your rebuttal, that will get you in a lot of trouble with some judges, because rebuttal is a response. It is not the time to be diving into new issues that nobody has heard in the argument until that moment. That is actually considered kind of rough, sharp elbows, shall we say, to your opposing counsel. So I apologize if I didn't hear it, but the severability issue, I at least didn't hear that earlier, and then we were getting into it. Similarly, you really aren't able to prepare a rebuttal, like preset thing that you're going to do. You kind of have to hear what happens in argument and bring up points. So be wary of sort of having like a preset rebuttal. It's just one of those things you have to be flexible and fluid and listen to what's going on and respond based on what you hear. That's the purpose of rebuttal. And then my last thing I'll just mention, and this is a tricky one. This is very much the advanced course. But for respondent, if you were asked a question and you're struggling with it and you're not quite sure what to say, that happens. That is life. Maybe you will have just a short response. It is not the end of the world to say, I don't know, to a judge. But what I think is ill-advised, and this is the natural human temptation, lawyers do this, is to just fill the space by sort of retreating to sort of a table pound of, well, the First Amendment is very important, and this case is crucial, or just kind of sort of wheel spinning like that. You're actually better off, I know it's harder, but just stopping and either saying less or I don't know or something like that than just sort of launching into a passionate appeal that is sort of just high level. But I thought you guys did fantastic. All of you, congratulations, very well done.
Yeah, let me jump in. If either or both of your teams advance the next round, don't mention Justice Jackson a question from the oral argument, because in theory you are arguing for the Supreme Court. I mean, it's almost this fiction where we pretend you can reference ideas, but don't reference the judges at the court. Just a minor thing, but to pick up on Corbin's point. Jacob?
Yeah, well, I'll echo everybody else in saying how extremely impressive everybody was. Again, it's hard for me to believe that these are high school students doing this, because I've heard many, many law student arguments that weren't nearly as good as these. So very impressive, and you should feel proud of your accomplishment there. As far as little points, little critiques, I did notice, and I think Justice Barry may have mentioned something about this, a lot of sort of unnecessary prefatory language that kind of sometimes kind of softens your points. Things like, I think we should, we humbly submit. And of course, these are things that you would say in normal conversation to be polite, and you do want to be polite and respectful for the judges. But at the same time, there really isn't anything to be gained by those unnecessary words, and it kind of makes you sound a little less confident than you otherwise might by just not asserting the thing in plain language without that kind of introduction. So I would work to cut those down in your arguments. I think petitioners, you answered a question and then you said, do you want me to conclude? And normally you wouldn't do that in an argument. If your time was up, you might, or it was just about to be up and you weren't sure if you had enough time, you might do that. But really, if you're done answering their question and it's clear they're not following up, you can just transition to your conclusion. And if they don't want to hear it, if they'd rather ask you a follow-up, they'll ask you the follow-up. but no need to ask them for permission to conclude if they're not asking you to do something else. Respondents, one thing I'll note that I thought you did well that that's important was you had a really good argumentative start to your argument. You got right to the point of Florida misunderstands censorship, and then you follow that up with a sentence or two that really was your core theme, your core argument. So no warm up or laying out background or facts. You got to what this case is about from your perspective. And that's an important thing to do that not everybody does, even in the real thing all the time. And I thought that was well done. On the rebuttal, I make the point that it was a lot. And, the points were well prepared and everything, but you wanted to get so much in. And that also prompted you to do what lots of lawyers do all the time in arguments, which is talk too fast. And because there were so many points delivered so quickly, like by the time I was thinking of my question for the first point, you were a point or two down the road because there's just so much you're trying to get in there. And I would instead just think about if you could only respond to one thing, what's the one thing you want to clarify? Put that up front and have a couple of backups and get in what you can very concisely, but not, but I'd trade clarity for quantity and just speaking more slowly so that the listener can process it and think of the question they want to ask and have a chance to ask it before you're on to something else. And that's true not only in rebuttal, that's true in all arguments. And advice that I've always appreciated about how fast you should talk is talk so slowly that you're sure you're talking too slowly, and then you're talking at the right speed, because that's the pace at which people can actually process all of it and have time to think about it and respond. And it isn't actually that slow. It just feels that way because for whatever reason, it feels natural to us to talk very fast when doing these arguments. So anyway, any suggestions there for improvement are relatively minor compared to, again, how impressed I was by how well everybody did.
Thank you so much.
Okay.
Thank you.
I'm happy to have some questions from the students for myself or for the judges, but law school, public interest law, the case, whatever you want.
So should we not bring in cases and standards that's not in the packet?
Oh, you're welcome to. You're absolutely welcome to. It's an open competition. I think my comment was just about don't reference what a justice said during the argument that happened in reality, but didn't happen in our competition.
And I was getting into, my point was, if you're going to do that, just make sure you thoroughly understood the thing you're going out, especially if you're going outside of sort of the core of the case. Really make sure you understand the thing that you are figuring out. And then also, if you go into something like the facial applied challenge, and you're going a little outside the core merits, you have to be ready for the fact that might in turn trigger, you're opening the door to who knows what. So that's the thing Tommy and I were talking about with, you get into facial versus applied and suddenly you're dealing with void for vagueness.
Oh, that's fine. We prepared a lot on that.
A related point, this won't affect you, is that the case may be decided the next week or two. So a couple of years ago, actually, we did Carpenter, which was a Fourth Amendment case, very fun case. And the court decided early, like the week before the tournament. So it's basically tell everyone, okay, this case was decided. We know it's decided, pretend it wasn't. And it didn't work at all. In fact, actually, bless his heart, Judge Kavanaugh was one of our judges that term, and then he had a very busy June. So he was presiding, but I don't think Netros we decided next week. I think this is gonna be a last week in June case, if I had to guess.
I'd be very surprised.
Ben, one more question. We already asked this to Professor Bachman, but I wanted to ask the judges this round as well. Like, what are your impressions of this case, or what you think might happen? Maybe
Predicting the future.
maybe. Oh,
I'll dive in, sure. I, in doing this competition, tried my best to put on my like Andy Oldham hat and be sort of a states guy, because in my real life, I think this is a very strong case for net choice. The judges, the justices, I think you've got your 5 votes for net choice. My shorthand is you clearly have Kavanaugh, and then you probably have Kagan, you probably have Sotomayor, you probably have Barrett, you probably have Roberts, and then we'll see about the rest. I think the question is it a ruling for net choice that goes as broad as maybe Kevin Newsom did for the 11th Circuit? Or do they try to figure out some way to make this like the most narrow possible ruling? Like, we're not sure what you can do, states, but you can't do this. And I definitely heard some rumblings from Justice Barrett and a few others that maybe that's what they're going to try to do. So I feel pretty confident about the bottom line result, but what the actual ruling looks like, I think, is very, very open.
thank you.
I don't have anything to add, but that all sounds plausible to me. I don't know. I don't have a confident prediction.
Yeah, I think Corbin covered it very thoroughly.
Thank you.
What other questions you might have for us?
I think I have a question. Law school, and we're kind of breaking up a little bit, like people are a little bit glitchy. So please just let us know if we can't hear it. I think me and Nitty, we both want to, and I guess since you guys are very well esteemed experience in like the law field, would you say that like moot these are highly emphasized in law school? I know that people complain about the amounts of like reading that people have to do in law school, but I would like to know what your guys' experience in law school, like having to go through this like a simulated trial.
I'm so sorry. I only got little bits of that.
Can you talk right into the mic? For whatever reason, I can hear it. Nitty,
I think if I understand the question, I think it was, do you do a lot of things like this in law school? What is that important in law school?
And did we do moot court competition when we were in law school?
Personally, I never did much of it at all. I think I had to do one oral argument in all of law school. There are some schools do have, of course, moot court you can participate in. I mean, there's some form of that that's optional at every law school. Some have advanced appellate advocacy courses where you would do more. And I think it's great to do as much of that as you can to develop just obviously if you're going to be a litigator, the more writing you can do, the more arguing you can do, the better, because these are essential skills, more on the writing side, but also the arguing. As somebody who hires lawyers, I'm very impressed by people who have those skills. You don't need to learn them on the job. So you're obviously well on your way. So like if this is where you are now in high school and you keep practicing through college and law school, I think you're going to be entering the profession as outstanding advocates.
Yeah, my experience was similar. So there's a first year, pretty much every law school has a first year, they call it different things, but it's like research and writing or advocacy course. That's just sort of the nuts and bolts of how do you litigate a case, where you'll do a simulated brief, a simulated motion, a simulated oral argument. And everyone has to do that. So I did do some simulated in-class oral arguments for that, which was very helpful. I remember being very nervous. And then most law schools have an optional competition, a formal moot court, they call it different things, where you can if you want to. And it is a lot. I did not do that. It seemed like a ton of time, and especially early in law school, probably prioritizing trying to get grades is more important than that. But it's kind of like the people who win in that are the closest we have to like the sports heroes, because if you go all the way, it's often like a Supreme Court justice is, at the final and things like that, and it gets televised, and people definitely will brag even 20 years later if they won, their law school moot court competition. But I definitely echo that the one way it's unrealistic is that real life lawyering is 99.99% writing and 0.001% arguing, which is not, of course, the impression people get from watching lawyer shows or just following Supreme Court oral
That's
arguments.
very genteel of you, Tommy, because litigation is like 80% like arguing with people on the phone and sending snippy emails and doing like doc review and dealing with crazy clients. And then
Right.
like 10% is writing. Yeah.
I was giving the amicus brief and appellate bubble experience.
Yeah, litigation is a whole other world. Although I will say, I recommend if you do want to be a lawyer, almost no matter what you want to do, and there's a vast range of different things lawyers do. It's like, I want to be a doctor. And it's like, well, do you want to be a radiologist? Or like lawyers, there's almost as much variety. And yet, my piece of advice I do give is it is wise to start out doing some litigation, like actual on the ground litigation, even if you're going to end up in policy. It is a valuable skill to know how courts actually work down on the level of the county court and the federal trial court. You will learn a lot of things there that, that's the only way to learn it. And even if it's a miserable experience and you get out of it after a few years, you won't regret it.
Yeah. One cool trend in law schools also is clinical education, which is becoming much more common. So in a lot of law schools now, you can actually participate in real case through a law school clinic for course credit and give you and see like if you enjoy it and not just simulation, but actually be working on what does litigation look like, where the professor is the actual sort of barred attorney who's leading a real case. So if you're interested in practicing and you do end up going to law school, that's definitely doing a clinic is one of the best ways to find out what it's like.
Thank you so much. That was great hearing that.
All right, any other questions? Well, let me thank both of you. I don't know if I'll see you either again in person or maybe online, but I do have such high hopes for you, and I'm always available if you ever want to answer any questions about law school or anything else. I'm always here. If you're ever in Houston, please drop me a line. We'll be announcing the results later today, so I know you're on pins and needles, but I know just hang tight, and I think we're gonna go deliberate as soon as we sign off here. So I'm gonna stop the recording. Say thank you very much.